people, if you lower your hands now, otherwise later it may be, I won't if you ask for information or if you want to do it, or if it's just still a hand that is lowered from before. So if you would be so everyone to lower their hands for now. Absolutely brilliant. So who are we? Who do we have in the room with us? Okay. Let's see who we have got here with us in the meeting. There you can see we have got a large percentage of people presenting the engineer or the consultant, very few people the contractor, a few people the employer, and your background is generally technical engineering, one or two legal people with us, and some other people. I'm glad to see that a number of people were also with us in the first session, but we will also just have a quick refresh on what has happened during the first session. At the start of the presentation, I would like to share with you information on two institutions which I'm very happy with recommending to you. We've got on the left-hand side the Institute of Construction Claims Practitioners. I'm actually a fellow with the Institute of Construction Claims Practitioners. And they are putting a lot of effort into training so that generally the submission of claims and the evaluation of claims are done properly. And on the right-hand side, RBF, the Dispute Resolutions Board Foundation, they concentrate on dispute avoidance, supporting dispute boards, and both of these are actually very, very noteworthy institutes, and they foster good practices in the of claims and avoidance. Just for your information, I have added their websites there. If you would like to take this down and consider joining them, I can really recommend them. Actually, both these institutions provide preferential rates for people of third world countries, which they also consider as being. All right, so let's have a look at a quick recap of session 1. Now, if we have a look at that, the question really was, is COVID-19 force majeure or exceptional event under FIDIC? And the final conclusion was, yes, under some conditions it is. Under other conditions it isn't. And the one thing which we need to just stress is, remember that we are talking of general principles here. It is not always possible to apply what we say here directly on your contract. It is important that we look at the specifics of your contract before you apply this. You will also, towards the end, my contact details are there, and you are more than welcome to contact me. Many of these things do need a trained eye to pick up specific items, and I am available to help you with that. All right, so COVID-19 force majeure, but what are the entitlements of the different contracts? If we look at the FIDIC, old FIDIC Red Book, which is used with PEC, there is no FM clause. And because there is no force majeure clause, there is no entitlement of the people of a force majeure under the old clause. Then secondly, if we look at the FIDIC 1999 and 2017, there's a force majeure clause. It does give you an extension of time entitlement. It does give you an extension cost entitlement, but only if it is in country and if it is a man-made event, as we have got that summary there. The FIDIC 20, or the general known pink book, it's also got a force majeure clause. It gives you extension of time. It gives you cost under certain conditions. But in both these, in all these cases, the one really challenging situation is under what conditions you do. And we've shown that really you nearly have to be able to suspend the work or part of the work before force majeure is considered an entitlement. So COVID can be considered a force majeure, but to have access to that is only when you are at that point where you stopping the work. So what is the entitlements you have? If you look at the situation, it is marked there. This is just a piece out of FIDIC 1999, and 2017 is similar, which says force majeure may include, but is not limited to, exceptional access of the kind listed. Sorry, we're just muting a few people here which doesn't have their microphones muted, which causes quite a lot of background noise. Right, and gentlemen, please do not annotate the screen. Everyone can see that. No one really wants to know your red lines on the screen. Mr. Leopold, Mr. Kishore Kumar, can you please close your microphones? Mr. Kishore Kumar, can you close your microphone, please? There is somewhere where I can switch off the annotations. Let me just try and find that. I'm not quite sure where that is right now. So we'll just do that. All right. So let's get back to what you can, under what conditions can you claim time or cost under force majeure. Now, if we look at the situation, under item 1, war, hostilities, etc., all will agree there was no war or war-like situation. So item 1 really doesn't fall as a entitlement. Then 2 to 4 can give us costs as long as in country under certain specific actions. But I think also if you look at the cases, it is very difficult really to consider this as reasons for your cause for force majeure, but these are all man-made. Then you can also have extension of time if it is a natural catastrophe. So in summary, extension of time is available. Cost only if it is man-made, because if it's a natural case, a natural occurrence, then you have to look at the insurance. So if we look at that, COVID-19 can be a force majeure event depending on the specific wording of the contract. The entitlements are limited and basically only if parts of the work is impossible to be performed. So if you can continue with the work, you do not have a force majeure. And then the other item which we said last time is try and start discussions early. Gentlemen, please do not scribble on the screen. The person scribbling on the screen, please do that. There was a question last time, but what about employer's risk? So let's just have a quick look at employer's risk before we look at other entitlements. Now, if you look at the difference between force majeure and employer's risk, the clauses really reads force majeure, exceptional event, may include, and then gives the list. The employer's risk under Pakistan Engineering Council's contract says the employer's risk are, and it gives a list, and the employer's risk under 1999 and 2010 says the risk referred in SC 17.4 insofar as it directly affected the works in the country. This is part of the pink R. Now, if you look at that, what do you immediately see as the difference between the force majeure clause and the employee clause? If you want to offer a comment, please raise your hand and I will ask you to open your mic and you can share with us your thoughts. The people that's got their hands currently risen, do you want to answer the question or is it just still for all? So Mr. Muhammad Ali Arshad, would you like to open your mic and tell us what you consider is the difference between the force majeure clause and the employer's risk clause?
Sir, there is a difference between the employer risk and the risk which is from the employer side. And the force majeure is the risk unexpected event. So it can be compensated by the laws and other clauses to fulfill the requirement of the site or project.
All right, but if you look at the list on the force majeure and the list under the risk is very much similar. So you are also quite happy in the chat to comment on what you think is the difference. Mr. Abdul Basit Khan, would you like to offer a difference? Would you open your mic and then you answer us what you think the difference? Mr. Abdul Basit Khan, do you want to unmute yourself and tell us what you think is the difference? Gentlemen, I'm just going to lower all the hands because I think some of these.
Hello, assalamu alaikum.
Yes, sir. Do you want to answer the question? All right, Mr. Abdul Basit Khan, you've got the microphone. Would you be so
Yeah,
kind
yeah,
as
I'm
to offer
listening.
your recommendation?
Hello? Are you listening me?
We're listening to you.
Hello?
It seems as if your microphone is switched on. We can hear you well, but it doesn't seem if you can hear us. We hear you very well, loud and clear. You're hitting on our ears. All right. Okay, let's try Mr. Hafiz Abdul Ahad Kouachi. Would you like to unmute yourself and offer a question, potential difference? Hafiz Abdul. All right, let me tell you the difference. It seems as if there is a little bit of a battle and a challenge to use the microphones and the hands. Mr. Sagar Rejawani, do you want to offer a reason the difference between the force majeure and the employer's risk? Saddam Hussein, do you want to, if as engineer Umair, I can see your microphone is picking up your voice. All right. Let me just quickly do a sound check. In the participants, could you all raise your hand if you can hear me properly? Aha, thank you very much. So you can hear me properly. Now I'm going to ask you all just to lower your hand again, and then we try again from start. So would you be so kind as everyone to lower your hand? All right, Mr. Farad Khan, your hand is still raised, and Engineer Hasib, your hand is still raised.
If you would allow me, so may I tell the difference in my point of view?
Hasib, you are more than welcome. Please go ahead.
I am grateful for the opportunity which you have given. As per my knowledge, I might be wrong. I think if a contract is having the clause of force majeure, it is just like an earthquake or a unnatural thing which you cannot control. So this comes into the force majeure criteria. Like the event is beyond the control of both the parties, the contractor and the client. It may or may not have been unforeseeable. I think this falls in the force majeure. And regarding employer risk, but I think I might be wrong. So you are here to obviously correct us. All the risks which are having an employee, for example, employer cannot provide the material on the time, or employees may not be able to give what the contractor needs. I think he's definitely wrong. Thank you.
All right, good question, good answer. Mr. Farad Khan, your hand is still raised. Do you want to offer a potential answer to the question? Engineer Umair Hussain, do you want to offer a answer to the question? All All right, in that case, let me tell you, if you look at the force majeure list of risks and the employer's risks, they are identical. They are identical except for this part on top, which says force majeure may include an employer's risk are. So although the lists are exactly the same, the situation is different with a force majeure is a non-exclusive list. It is items similar to, but in the employer's risk, if you do not have the specific items in that list, then it is out of the, then it's not the employer's risk. So if you look at the main difference between the approach of the two clauses, the force majeure is not exclusive and the engineer's risk is an exclusive list. If it's not in the list, you cannot use it. I'm not going to talk about FIDIC 2017 because that clause is drastically rewritten and it is very different to any of the previous FIDICs. So if in employer's risk, 1 to 5, as we looked previously, there is no opportunity. But now if we look at the Pakistan Engineering Red Book, employer's risk also include any operation of forces of nature insofar as it occurs on the site, which an experienced contractor, etc. So now if you want to use COVID under FIDIC PEC Red Book, first of all, you need to be able to show it's a force of nature. Now, COVID may be a force of nature, but it didn't happen specifically on site. If you had so many people that contracted COVID-19 on your site that you had to close your site, then you can say employer's risk. If not, really you do not have a case under employer's list. So you need to be able to show that COVID is a force of nature. You also need to be able to show that it happened on site. So only on your site, not outside or in the vicinity, it must be on site. And if you can't do that, it is definitely not an employer's risk under the old Pakistan Engineering Council contract. Now, I'm going to ask you to tell me if you are in agreement with me or not. So I'm going to ask you, do you agree that it cannot be or very difficult to be an employer's risk, or if it is going to be an employer's risk? So gents, if you could tell me, do you think you can, under general conditions or under general situation, use the employer's risk as an entitlement to COVID or not? All right, we're going to give a few more moments for people to make a selection if they believe it is possible under these conditions to have COVID as an employer's risk. It's actually interesting results. I can see how you are. I can't see who I can't see who vote, but I can see what the count is. All right, let's close the poll and I'm going to share that with you. I'm actually surprised that people think you can use employer's risk in these conditions? Out of interest, how many of your people had sites which closed because of a massive number of COVID cases on the site? Would you be so kind as in the chat just to say my site, if your site closed or any of your sites closed because of the actual number of COVID cases on the site? Mr. Safazal, you said your site closed for 2 months because of actual COVID cases on the site or because of the general closing of the sites because of the risk of COVID? No, smartly lockdown is not a reason. Smart lockdown did not, will not give you an employer's risk. Smart lockdown, you did not have 50, 60, 80% of people with a positive test on your site. Possible cases, not on your site. You cannot show that there you could not continue your work because of the large number of COVID cases, positive COVID cases on your site. All right. Do you understand why you cannot really, or under very, very, very extreme cases, you can use employer's risk? I am going to relaunch the poll, and after that discussion, so I would like you to review your earlier response and tell me what is your belief now. Can you use employer's risk? Can you not use employer's risk? Just remember that if you say you can use employer's risk, you must be able to say 50, 60% of actual COVID cases on my site forced us to close the site. Smart lockdown, instruction from the employer, it's not the same thing. Mr. Salman Khan, I see you raised your hand. I'm going to ask you to unmute your, oh, okay, you dropped your hand. Okay, I'm going to end the poll there and I'm going to share the results with you. Still a lot of people believe that they can use employer's risk. I need to caution you to be very careful about that one. It is going to be an exceptionally difficult case to prove if you consider that. All right, let's go on. And let's look at alternative entitlements. We said force majeure, it's possible, but it's not a very good entitlement because you basically can only claim if your work is suspended. Secondly, employer's risk. All right, we agree to disagree on that one. Gentlemen, please don't scribble on the screen. So the second step is let's look at alternatives. What can you use which are a much better entitlement? And there are basically a few different things. From a contractual point of view, you can look at health and safety, shortage of resources, changes in the law, and some other items. From a legal point, you also get frustration. So let's first of all look at health and safety or epidemic. If we look at what the FIDIC 1987 or the Red Book, the Pakistan Engineering Council book says, it says that the contractor shall further ensure that suitable arrangements are made for the prevention of epidemics and for all necessary welfare and hygiene requirements. In the event of any outbreak of illness of epidemic nature, the contractor
उसको बंद है
all right, then the contractor will be able to comply with, the contractor shall comply with and carry out such regulations, orders, and requirements as may be made by the government of the local medical or sanitary authorities for purpose of dealing with and overcoming of the same. So, no force majeure is described in the FIDIC contract and in the FIDIC 1987 contract. But it describes epidemics specifically, which gives you quite a good entitlement. Now, subclause 34.6 says regulations, etc., as published by the governmental organization and 34.5, the prevention of epidemics, which is a contractor's duty. So there is possible entitlements under the Pakistan Engineering Council contract. But the question is, what is the baseline condition? The baseline condition is what could reasonably expected at the time of tender? What was reasonably foreseeable at time of tender? Not what has been foreseen, but what was reasonably foreseeable at time of tender. So if you submitted your tender before January, and if you submitted your tender after March, two major different situations. Let's have a look at FIDIC 1999 and the Pink Book, which says health and safety, the suitable arrangements are made for all necessary welfare and hygiene requirements and for the prevention of epidemics. It doesn't specifically list here your entitlement. We're going to a little bit later touch on that specific item. How do we get to the prevention of epidemics? Why does this give you an entitlement? So that is health and safety. Let's look at the next one. Shortage of resources. Now, the people using FIDIC 1999 and 2017 are actually quite fortunate because it specifies specifically as an extension of time factor, unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions. All right, so in this case, unforeseeable shortages or epidemic governmental actions. Now, we are going to look a little bit more on changes in law, which will touch again on governmental actions, but in this case is governmental actions to prevent epidemic. There's nothing specific for shortage of unforeseeable shortages in the FIDIC 1987, but there is a clause there which we can look at to help you. But remember this, only extension of time entitlement. This is part of the extension of time clause. So at this stage, only extension of time. Now, let's look at what I consider as one of the most strong entitlements is changes in law. Now, if we first of all look at, if we look at the FIDIC 1987 book, subclause 70.2 says, changes to any national or state statute, ordinance, decree, or other law, or any regulation or bylaw of any local or other duly constituted authority, or the introduction of any such state statute, ordinance, decree, law, regulation, or bylaw, which cause additional or reduced costs to the contractor, etc., etc., etc. Now, have a look at that. It's an incredibly wide application. It really, the writers of FIDIC really tried to give you as wide as possible changes in legislation. It is not a restrictive clause, it's an incredibly wide clause. Now let's have a look at that same or similar clause in the 1999 and the 2010 version. Changes in legislation resulting in decrease in cost, increase or decrease in cost resulting from the change in the laws of the country will give you an extension of time and payment of costs. What is interesting, if we look at the FIDIC 1987, that only gives us an entitlement to cost. It doesn't give you an entitlement to time. However, the 1999 and 2010 gives you entitlement of time as well as cost, and the 2017 as well. So, what laws, what country? Let's have a look at the definition. It tells us the country means the country in which the site, or most of it, is located, where the permanent works are to be executed. So in general terms, if there's a law change in China, that doesn't apply to us here. If it is a law change in Spain and you get a lot of your spare parts from Spain, doesn't allow here. It is generally the country of the site. And usually it describes, in our case, the site or the country as Pakistan. Law, again, all national or state legislation, statutes, ordinances, and other laws and regulations and bylaws of any legal constituted public authority. Again, an incredibly wide application. So if NHA make a regulation to say because of the following, you need to do something, that is considered as a change of law under FIDIC 1999 and 2010, because Gents, you lost me there. I lost you for a moment there. I hope to be back online now. Let me just share the screen again. My apologies for that one. It was an internet problem. And I would just like to see if I still got hosting capabilities. Yes, it seems if I do have. All right. So FIDIC 2017, very similar. Again, the amount, the law is written incredibly wide.
अभी लाइन खोलिए फिर दोबारा खोल के बॉल कॉक लगा के दोबारा उतारिए लाइन मैं मतलब को भेजूं एक काम ये करिएगा यहाँ से ना जहाँ पे मैं मतलब बता दूंगा दूसरी बात ये है कि वो एक लाल वाला वाल बंद कर दिया इधर वाला खोल दिया फिर 5 नंबर पे जाएगा फिर क्योंकि आपको पानी नहीं ना देखा आपने लाल वाला वाल खोल.
All right, let's continue. So we go back to changes in the law. Very strong option in changes in the law. I just wanted to make sure we are still recording, so that is good. We go back to screen share. Now, the next item that we have got there, we had looked at health and safety. We looked at unexpected problems with resources, and we looked at items on changes in the law. Now, the other item that we do have is other factors. Now, let's look now at the 1987 PEC contract. And you can see it says extension of time for completion, other special circumstances which may occur other than through default or breach of the contract by the contractor for which he is responsible. Now, generally, most of the changes in law under this contract will be special circumstances which will give you an extension of time. So you can get under this change of law, you can get a financial entitlement, and under this situation, you can get a extension of time entitlement. Engineer Mohammed, the problem is the contract is in English, and usually the contract language is in English. That's why it is such a challenge, I know, for Urdu. But all right, maybe Pakistan Engineering Council can arrange that. The important thing for this contract is, if you look at the notice of claims, you have got another option as well. The notice of claims says, if you consider to claim any additional payment to any clause of these conditions or otherwise, you shall give notice. So you have got, under the previous one, we showed you extension of time, and under this clause, a blanket potential for money. Now let's look at FIDIC 1999 and 2010. This also say, under the claims, you have got time for completion or additional payment under any clause of these conditions or otherwise in connection with a contract. But the onus is on the person that claims, the person that submits the claim. He must be able to prove his case. Mr. Ali Abbas, I saw you raised your hand. Would you like to share something with us? If you could unmute yourself and share with us what you would like to share with us. Mr. Ali Abbas?
Hello, can you repeat the last slide? You have control.
Are you talking about the one of the FIDIC 1987, the one that I've got on the screen?
Yeah. Yes, I was talking about this. This slide should be repeated. Can you please?
All right. If you look at this clause, it basically gives you an open package. You can, if you want to claim money, you've got to claim that based on, you need to give notice of any additional payment. If you intend to claim any additional payment pursuant to any of the clause of these conditions, you've got to give notice to claim. But if there's something different which you would like to claim money for, it is also allowed that you give a notice. So, notwithstanding any other provisions of the contract, if the contractor intends to claim any additional payment based on any clause of these conditions or otherwise, he shall give notice. But that or otherwise is a very difficult reason how you can do that. That is in the case if you go to the legal way and if you go to the Pakistan Contracts Act and you find something there and you'll say, I want to claim on the contract additional money based on the Pakistan Contract Act. That is where this comes into play. Does that answer your question, Mr. Ali?
Yeah, thank you for the slide.
100%. Now, a similar situation is also in FIDIC 1999 and 2010, where you can claim extension of time for completion or additional payment under any clause of these conditions or otherwise in connection with a contract. And if you look at any of the arbitration clauses, that is something similar. It is a very wide open entitlement. But remember, it is the contractor's the contractor has to prove his case, or if the contractor needs to prove his case. Now, 2017 is interesting. 2017 changes the approach a little bit. It says that the same rules for claims apply to the employer if he wants to make a claim against the contractor. The same rules apply to him that applies to the contractor if he wants to make a claim against the employer. But again, you have got any kind whatsoever allowable there. So in summary, let's have a look what are the entitlements. We looked at health and safety. We looked at shortage of resources. We looked at changes of law and other. Now, first, if we look at the old FIDIC Red Book, which is used by Pakistan Engineering Council, health and safety may give you an extension of time entitlement. It may give you a cost entitlement. Shortage of resources, there's no specific entitlement. but changes in law gives you a cost entitlement, and other items can give you a extension of time entitlement. Let's look at FIDIC 1999 or the Red Book. Again, health and safety. I think you've got a reasonable entitlement for health and safety, both extension of time and cost, if you can prove it properly. And then shortage of resources give you a extension of time entitlement. Changes in law give you both an extension of time entitlement and cost. Other items, both, and a similar situation in FIDIC 2017. Ladies and gents, I just want to emphasize what I said earlier. This is
Hello. The audio is gone. Hello.
We can't listen your voice.
Audio is gone.
I think he has internet disconnection. We have not only lost his voice, but also he's disconnected.
I'm back.
Yes, he's coming back.
I'm
He's
back.
coming back.
We had a power failure here on site. I'm sitting in the
I think
north of Pakistan,
there is a returning connectivity.
and
No problem,
we have
Christian.
some
No problem.
challenges. So at least we are back online there. Let's just go through the process again. Let me get everything ready here. Let me share the screen with you. It's actually incredible if you look at the technology. We have got, I'm sitting here absolutely in the north of Pakistan. We've got people all over the whole of Pakistan, and we're all talking with one another. Just want to make sure everything is.
Definitely, sir, that's a plus point, and the technology has come so far. It's a plus point. It's a good thing.
This COVID-19 has totally changed the world dynamics, basically.
You know, when I was working on Neelam Jeelam 10 years ago, at some stage, I actually managed to get our board of management using Skype for meetings. So there we sat, we had people sitting in Chicago, we had people sitting in London, we had people sitting in Oslo, we had some people in Lahore, we had people in Kashmir, and we talked with one another. The technology has been there that long, but the attitude or a little bit of something against using it. And now people has accepted that you can actually do this. All right, let's go on. There's the summary. Health and safety, shortage of resources, change in law, other. These are your strong entitlements. Yes, the contractor still needs to make his case. He cannot just open up and go as he wants to do. It's still his responsibility. It's still him. He has to still do it. And remember what I said in the beginning. just because you've got the entitlement in the general contract, you need to look at your specific contract. There may be some general conditions, there may be some particular conditions of contract which gives you a little bit of a challenge to do that. You may not be able to do that when you look at your own contract. All right. Management. Let's have a quick look at claims management. I'm not going to go into detail on the claims management. I just want to touch on a few important things. Notice, records, absolutely important. I've seen most of our people here are people representing the engineer, a few people, the client. And I beg you, I urge you, start talking to the contractor. Set up something. We have got a absolutely something totally different, unprecedented situation. Don't rely just on the contract. Talk with one another, find ways on how
Hello?
you can continue and have some fun. Yes, Mr. Mohammed Abdullah, you are trying to talk to us. All right, so that basically wraps it up. So I'm going to ask people who would like to ask questions to raise their hand, and we are going to give you now the opportunity to talk with us, and let's see who wants to have something. So anyone who would like to share some comments, who have got some questions, please raise your hand, your virtual hand, so that I can see and then ask you to join with us. Hamza Shayan, I am asking you to unmute you and then ask your question. All right, Hamza disappeared on us. Anyone that would like, Mr. Mohammed Abdullah, you want to ask a question or make a comment? If you would unmute yourself, then please go ahead.
Yes, does this seminar have CPD points?
As far as I know, yes, it does.
Okay.
That is something like which Pakistan Engineering Council will administer.
Okay, thank you.
All right, Mr. Usman Ilyas, would you like to make a comment? Anyone else that would like to have anything to say? Muhammad Ali Said, please go ahead.
Couple of slides before in the FIDIC 2017. Time of extension of time clause. Can you repeat that?
You want me to repeat
which? Yeah. And furthermore, can we have a soft copy of this presentation that you are showing?
The whole presentation, this whole webinar is being recorded, and it will be uploaded and accessible through the Pakistan Engineering Council website.
Thank you.
All right, your question about extension of time, under which contract are you talking about?
FIDIC 2017, latest one.
Which year? I didn't hear. Just repeat.
FIDIC 2017. The last slide.
2017. All right.
The last slide you have shown before the summary.
2017 gives
Extension
you
of time.
a similar clause for extension of time as the 2010.
Was the last one before the summary?
And I think it is subclause 8.7. You can just check. I think subclause 8.7. All right, then we've got, does that answer your question, Mohammed?
In that clause, it was written that employer is also entitled for the claim.
Yes.
And in that subclause, it is written that DNP, for the DNP. May I ask what is DNP?
Let me quickly.
Yeah, this one.
Defect notification period, I guess.
Yes. Thank you.
Thank you.
Actually, in the definitions of 2017, it gives you a long list of acronyms, so you can pick it up very quickly from there.
Because in FIDIC 99, it is mentioned DLP, defect liability period.
Yes. Now you're 100% right. Thank you for that clarification. All right.
Is it the DNP and the DLP are both are the same?
It's
Yes,
similar.
I guess so.
It's similar.
Mr. Christian, can you elaborate this class a little bit more? Because it's the latest FIDIC. I'm interested to know it, this class a little bit more. Can you explain? Thank you.
Mohammed, I couldn't hear you well. Would you please be so kind as just to say again?
Christian, I want to have a little bit more information about this class because it's the latest in the FIDIC 2017.
Okay.
Can you put a little bit more light on it?
Yes. The interesting thing about the older FIDICs, or the FIDIC 1999, there was one set of rules if the employer claims against the contractor. And there was another set of rules if the contractor submits a claim against the contractor. If the contractor submits a claim against the employer. 2017 has changed this approach. They said what is good for the goose is good for the gander. So the same rules apply if the employer wants to claim against the contractor. The same rules apply as when the contractor wants to claim against the... Yes, that is an interesting change in approach. They just made it a similar way. They balanced the books. I hope that answers your question. That is why it is a little bit more extensive. All right. We've got another open mic here. If Mr. 1IL7OSYH18X6ARMXZK want to ask a question, you're more than welcome.
Hello, can you hear my voice?
Yes, we can hear you very well.
Okay, sir, I have a common question related to COVID-19. That some people say that COVID-19 is man-made. What do you think, that it's a force majeure or a man-made or some conspiracy regarding this?
Okay. Sorry, this is totally outside of this thing. I'm not going to even try and go that route. That is not going to help you in any claim of COVID. We are concentrating here on the contractual entitlements.
Okay.
So I'm not going to comment on that one.
Okay, better, good, thank you.
Yeah. Mr. Mohammed Yassin, you have a microphone. If you can talk to us, you're more than welcome. If not, just make a question in the chat column and I will have a look at that. And then secondly, or next then is Feroz Mughal, you have got your hand up and you've got your mic open. If you could go ahead, please.
Can you listen?
We're hearing you well.
Well, sir, you have already explained about claims of contractor. Actually, I am working on the same nature project of 750 million, where our project was delayed for at least 3 months due to this COVID-19 situation. And the contractor had already claimed because of idleness of his machinery and manpower. So my question is that there is a clause that contractor can claim because of force majeure condition, but I want to know that what is the percentage, that how will we find that what will be this percentage of his claims? Is there any formula or clause that we can calculate his claim?
You have to look at his claim. It is his duty to substantiate, first of all, his entitlement, and secondly, his quantum. So you must go and look, is this really force majeure? Why did he stop? Why did he stop?
Actually, he has already submitted a letter where he has mentioned that FIDIC read 1987 book clause, that with that clause we are going to claim because of idleness of machinery and manpower. But they did not.
1987 doesn't have a force majeure clause.
Okay, maybe it is according to our special terms, special conditions of contract.
All right.
But I was finding out that, but there was no any percentage formula, so that's why I was confused that how can we calculate his claim? So that's why I was asking this question.
All right, there isn't a quick fix. You need to understand the whole process. There isn't a quick fix. There isn't a something, thumbs up, it's 10%, 20%. He has to show you his costs, not his damages. Go and read your FIDIC. It says costs. He must prove his costs. He must show to you, this equipment stood, this is what it's costing me, and he has to link this with the stoppage, and he has to link the stoppage with the COVID.
In short and long, you want to say that it is actually contractor responsibility to let us know that he should actually mention all his machinery or whatsoever he claims. So it is his responsibility to submit that extra bill.
It is absolutely his responsibility to submit. It's his responsibility to show. It's interesting if you look at, large claims globally, one of the biggest problems for disputes or issues of disputes is contractors do not give you proper claims.
Okay.
That is one of the biggest, that's the biggest cause for disputes globally, internationally. The contractor doesn't provide you with a proper substantiation.
Okay.
If you need assistance in that process, and if you need to look at the potential of dispute resolutions, you're more than welcome to contact me offline. Just now again, at the last thing, I will again show you my email and my phone number. You're more than welcome to contact me offline. But one of the things where contractors fail often is they put a few pieces of paper in front of you and they expect you to give you time and money.
Absolutely. This is the question actually I want to know about you. I'm also facing same problem. So I actually go through those documents and I didn't find any other clause that from how I can calculate his claim. So actually, yes, I have more things to discuss, but later on when you
Yeah.
will offline, I will ask about this thing. So
You
thank
can
you.
do that. You can do that. All right.
Okay.
Mohammed Ali Said, your hand is up. Do you want to ask a question, or is that still an old hand? Let's give Mr.
Thank you.
Mian
Question.
chance. Mr. Fazullah Mian, if you would unmute yourself and ask your question.
Yeah, thank you, Mr. Christian, for the opportunity. The question is that from contractor's price point of view, the entitlement for force majeure, in my understanding, will be purely for the extension of time. But if we are going to claim for the other entitlements, like the entitlements arising out of in connection with the change in law or unforeseeable circumstances, that will give rise to the contractor's entitlement for cost also. So what is your view on this?
Hold on, I just want to put a screen, share a screen here, a specific screen here. All right, your question is force majeure, extension of time, cost. First
Yes.
of all, force majeure, you have got in FIDIC 1999, 2010, 2017 gives a extension of time entitlement for a number of cases. 1999 and 2010 and further also give you an entitlement for cost under certain conditions. Let me get that specific summary here and share that with
Sir, your voice is vanished. Sir, are you using PTCL Wi-Fi?
Sir, the voice has been gone.
He is using internet 2G. Just 2G, I think.
Until
Sir,
then,
we lost
P
your voice.
should be the host.
Hello.
I think the seminar has ended.
No, it hasn't. It hasn't. I just lost power. Sorry again, gents. I'm back with you.
Okay, okay.
All right, let me share the screen again.
His internet is lost again.
Hello.
Sir, are you there?
इस्माइल साहब अपना काइंडली माइक म्यूट कर दें. इस्माइल मोहम्मद इस्माइल सिविल 53274 काइंडली माइक म्यूट कर दें.
आई थिंक मिस्टर क्रिस्टियान का कोई इंटरनेट का इशू आ रहा है, तो जरा वेट करें. सारे ज़रात आ जाते हैं, वो जैसे उनका नेट आएगा तो वो डेफिनेटली कनेक्ट कर लेंगे. Gentlemen, the joys of electricity. I'm back here online. Let's just try and
pick up where we were. All right, this is where we were. All right. If you would be so kind, I just want to get everything in place here. What does it mean? All right, let's continue. I hope you can hear me. Just in the chat, just say all okay now. Hopefully it's fine. Thank you. Great. All right, let's have a quick look on force majeure. FIDIC, just a summary. FIDIC, Pakistan Engineering Council, no force majeure clause, no entitlement. FIDIC 99, 2017 and 2010, there's a force majeure clause. You can get an extension of time. You can get cost under certain conditions. But the big challenge is you have to have the situation really so much so that it caused you to stop the work, to suspend the work. And you need to be able to show those specific items. Generally, you will find that the other entitlements I gave you is easier to prove, is easier to stand up in a dispute. I hope that answered the question, Mr. Fazullah. I think you were the person that asked the question.
Yes, Mr. Christian, thank you very much. But honestly, I would like to rephrase the question once again. So the question is that from contractor's perspective, for example, I'm representing a contractor, right? So I would like to have the recovery of my additional costs which I have incurred because of this pandemic situation. And if I'm going to, if I'm going to claim this as an event of force majeure, it will be a little difficult, like you have rightly said.
Absolutely.
So what is your opinion? Will I be entitled to be compensated for the other provisions of the whatever FIDIC forms say 2010 or 1999 or 2017?
It depends on, okay, look, it depends on which contract you're using. You cannot jump out of your contract into another FIDIC contract. The question is, what is your contract on site? Which are your contracts that you're using currently?
Yeah, actually, my question is honestly general in nature. For example, the table.
Contracts are not general in nature. That's the problem.
Actually, my question is general in nature, not the contract. I'm not talking about the contract. My question is general in nature. So, say for example, like the table which is right now on the screen, FIDIC Red Book, no force majeure clause, no entitlement. Okay, agreed. So, but this is a factual circumstance that the contractor has been delayed, his works are delayed, and he has incurred additional costs, right?
I'm listening, yeah.
So there are other provisions within FIDIC Red Book which a contractor can claim his entitlement, like, yes, alternative entitlements, exactly what you have shown right now.
Yes. Now, I would lean towards any of these or a combination of these rather than force majeure. All right, good. Mr.
So
Ghulam
can you
Nabi, okay, you go first. Go,
yeah,
continue.
can you put some more light on the legal, i.e. the frustration of the contract?
All right, that is an allowable in the Pakistan Contract Act, which allow you, I don't have the specific clause now, but you say it is a condition where the situation has become so, you are so frustrated because you cannot continue with your contract, but that only allows you to step out of the contract. It doesn't give you any recovery of costs or damages. That is basically just a way how you can, where you can terminate the contract.
Thank you very much, Mr. Christian. Actually,
Okay.
we would have, yeah, if you would have touched upon the program side of the contract, then it would have been more useful, honestly.
No, you can work on the program. If you've got no entitlement, I can talk to up to 3, 4, 5 hours on programming. And that is a total different aspect if you look at calculation of time or time entitlements. But if you don't have the entitlement, no program is going to give you time.
Absolutely right. So actually, entitlement we have discussed already that we have entitlement for example, whatever is you have shown on the screen, or force majeure, whatever the case is. But there is some other aspect. For example, first we have to prove our entitlement, and then we have to go to the programming part of the claim.
Correct. Absolutely. Mr. Fazullah, you can contact me offline. You're more than welcome. I can help you. I can give you some guidance. Yeah, at this stage, look at what we've said there. Mr. Nabi, you had your hand up for some time already. Would you like to open your mic and ask your question? All right, now your name doesn't come down. So Mr. Ket Kumar, would you like to open your mic and ask a question? All right. Mr. Muhammad Ali Seed, I think your hand is still up from previously. Mr. Muhammad Hassan. Okay, continue.
Mr. Christian, these alternative entitlements are in case of fees red book only. I think so, because there is no force majeure condition. Is it applicable for the rest of two FIDIC documents?
These entitlements are generally available in all FIDICs. If we look at the summary again, I just want to get the summary. There's your summary. Those are different FIDICs. Health and safety. You need to be a little bit creative in writing your narrative. Then you can get this entitlement. Shortage of resources, definitely in the FIDIC 1919 and the 2017. Changes in law on all FIDICs, not extension of time under the old Red Book, but under other, you can get extension of time, and also on the other FIDIC contract. Does that help?
800 minus the 35 we discussed it.
Mr. Abdul Qasim, does it help you, that answer?
Yeah, thank you, Mr. Christian.
Okay, good. Mr. Abdul Basit Khan, I see your microphone is open. Do you want to ask a question for us? Or Mr. Mohammed Ashan Mustafa, your hand is also up.
Yes, sir. I want to ask some question here, Mr. Christian.
Please proceed.
Okay, thank you. It's actually not a question. It's a expert opinion I want to actually ask from you. I work with a client organization, and with this current pandemic situation, we are actually following a red book, E&M yellow book contract as prescribed by PEC. And in our case, in our scenario, we have a JV partner for a local firm, and the foreigner partner has been severely affected by this pandemic situation. It's in Europe. So engineer has considered the notice for this one, the foreigner partner, and but for the local partner, for the local JV, engineer has said that the works are not yet that much affected by pandemic. So I want to ask from the client perspective that, well, in this situation, would the contractor be entitled for an EOT, or should we impose an LD in this case? How to proceed with that?
What does your gut tells you?
I think since engineer says that local JV is not affected, so we think a contractor is not entitled for EOT.
All right. Remember, all these FIDIC contracts try to be fair. I looked at the PEC yellow book, but I didn't put it in on this one because in the previous session there was no one which were using it. But the PEC yellow book, if I remember, actually has got a force majeure clause in. Now, what I strongly suggest and recommend is sit around the table with the contractor. Talk to him, hear his side of the story. Don't just look at the contract and make a ruling. At the end of the day, the situation currently is really unprecedented. And you need to look carefully at the actual situation to say, yes, he is entitled to an EOT or not. At the end of the day, the contractor needs to prove his case. He needs to be able to convince you contractually defendable why he should get an extension of time. It is not a blanket. It's typically like most lawyers, I will answer you with, it depends. It depends on exactly what is the situation in the contract, what is the exact influence this had. But I would really say, have a chat with a contractor, hear his side of the story as well before you make a final ruling.
I understand you. Thanks a lot for your
opinion. It may really help you to bring in a dispute board. Even though that yellow book doesn't have a dispute board, is consider bringing in a specialist to mediate to find a solution.
All right, we will go for this amicable settlement.
Have a look at that, yes. Haider Ali, you've got your hand up. Do you want to open your mic and ask and share your thoughts with us? Mr. Haider Ali? Please proceed.
My name is Haider Ali. From client point of view, this pandemic is natural. This is from God. So how I will bear the cost from contractor side? How I will give the extra cost to the contractor without? I agree with this that only extension of time is possible without cost. So that is my question. So as a client, how as a client or as an employer, how I will bear the extra cost? Thank you.
Okay. It depends a lot on how the contractor structure his claim. Now, he can say, yes, it's force majeure. Then there are a certain set of rules he has to comply with to give him entitlement. He gets certain entitlement under certain conditions. Now, the onus lies with the contractor to come to you and prove his case. If it's good enough, he can come and he can share that with you. He cannot just walk into your office and say, act of God, I want money. No, that cannot happen. But he doesn't only have to use force majeure. If you're on the FIDIC 99, for example, he can say shortage of resources, extension of time. Or he can say there are so many regulations and changes in the law, regulations, smart lockdown, all those things, that's a change in law. That gives me a cost entitlement. So it depends on how he structure his claim and how he substantiate his claim. And this is the contract that the two of you entered into. But again, I suggest this, go and sit around a table, listen to one another, try and find a proper amicable way to address that, and then follow the contract. Get some pre-agreements and then follow the contract. I hope that helps you.
Thank you, sir. Thank you.
Okay. All right. Mr. Mohammed Ali Said, do you want to talk to us?
Yeah. We should stand under the other subhead. What can be enlisted?
Your sound was very poor. Would you be so kind as to try and ask the question again?
I want to ask that under the other subhead, can you enlist the items? Can you hear me now?
Yeah, okay. So under other items, what can you list or what can you do? Other items basically opens it up. You can go to the Pakistan Contract Act and see if there's anything there where you think we can support you. You can use the other health and safety. You can use the other because under other you get the way how it says to you how to claim. So health and safety doesn't tell you what are your entitlements. You can use other to say, look at health and safety, this is the situation. And you can have those type of things. FIDIC 1987 include other as a specific item for EOT. There you can say, other COVID influenced me in the following ways. Remember, you've got to follow. It's not just you say, COVID, therefore I want extra time. You must say, COVID stopped me from doing this. It's a direct link and therefore extension of time. COVID stopped me. I couldn't get material in. That delayed me. It delayed me this much. I can show you by per program. Therefore, I can claim extra time. This is where other comes in. I hope that answers your question.
Yeah, and where in the contract, can you specifically mention the clause under which other is covered? We can say under percent clause so and so.
मेल छिलाइए को नहीं आ गया मुझे मेल तो लिंक किया इन्होंने.
Other is specifically as part of your EOT claim, and on the other items, you also have under the subclause 20 allows you to look at items wider than the contract.
You are referring to Red Book, PEC 1987.
PEC Red Book is extension of time, and gives an entitlement for other, and it gives you under health and safety. I can't remember the exact clause. You can do your homework and find the specific clauses there. All right, I hope that answers your question. Mr. Naheem Akhtar, do you want to open your mic and talk with us? Nadeem Ghaffar, okay, you talk to us.
Yes, sir. Yes, sir. First of all, I want to say thanks to you on behalf of my Pakistan Engineering Council and all the engineers here in Pakistan. Thank you so much for giving us time. I want to understand FIDIC 2017. One thing, let us simplify. If you are the employer and I am the contractor, once the contract is made, and the new clause is that there is an additional payment. Like, is it some kind of penalty, the power which both parties can have?
All right, 2017, remember if your contract is under 1999 and 2010, you cannot jump to 2017.
Right.
Your contract is your contract. If you've got the old FIDIC Red Book, you cannot jump to 1999 or to 2017. Your contract is your contract. Now, if you look at 2017, if you signed a 2017 contract, if you look at the old FIDIC 1999, you had contractors' claims under subclause 20 or under clause 20, and you had employers' claims under 2.5, clause 2.5, subclause 2.5. FIDIC 2017 do not have a subclause 2.5 contract employers' claims anymore. It now only have got claims under clause 20. So there you have got both the same rules. And this is just how it is structured. The same process, the same procedure needs to be followed by the employer if he wants to claim against the contractor, and the same procedure has to be followed if the contractor has to follow, he has to follow the same procedure if the contractor wants to claim against the employer. I hope that clarifies your question.
Yes. Thank you so much. Again, thank you. Thank you.
Okay.
God bless you.
Naim Akhtar, do you want to open your mic and talk to us? All right, Mohammed. Faisal Mian, Mian, your hand is still up. Do you still want to talk to us?
Yes, Mr. Christian, I would like to ask one another question.
Please proceed.
Yeah, regarding the table which is right now on the screen, my question is it possible for a contractor to claim under clause 12.2, i.e. the physical, unforeseeable physical obstructions or conditions, is a summary of alternate entitlements instead of force majeure?
Unforeseeable physical
obstructions.
Obstructions. How were you physically obstructed?
Yes.
I'm asking, how were you physically obstructed?
Okay. The COVID-19 has created circumstances which has created obstruction on the site. For example, I was restricted from attending the project, and as a result, the pace of work was slowed. So it is creating physical obstruction. Honestly, for example, if there is an instruction of lockdown by the local authorities, or even if the contractor is taking extra measures, i.e. for health and safety, and it is creating such a circumstance because of this physical distancing and social distancing,
How many COVID viruses stopped you from coming onto site? You had 2,000 COVID viruses standing at the gate and said, we will not allow you in.
Yeah, but it again goes to the safety. For example, the safety,
yes,
the safety
it's
regulations.
Not a physical. It's
Yeah.
not a physical. You're right. You're quite right to say it is a health and safety regulation. Regulation is a change in law. Understand?
But what about physical checkpost, police checkpost, which obstruct from coming to the site?
You were not. If there were guards, if the employer set certain guards in front of you and said, you are not allowed to enter the site. We prevent you from entering the site. You cannot enter the site. Then you have got a physical obstruction, but that may be rather a suspension. There isn't some, be very careful about that one. It's very difficult to prove that there's a physical, remember the word physical obstruction. It's not a regulatory obstruction. It is not a legal obstruction. You want to say a physical obstruction.
But with due respect, it says physical obstructions or physical conditions. So it is not just physical obstruction, it is physical condition also.
Christian, please elaborate this physical obstruction that you're talking about. What actually is physical obstruction?
Physical obstruction is you start excavating, your geotechnical baseline report said it is soft. The next moment you hit rock. That's a physical obstruction. That is something you have to change your whole methodology because the information that was given to you was wrong. Or a physical obstruction, you're busy tunneling in basalt, which you think is basalt, and the next moment, out of nowhere, there's a zone of sand, and the sand drops down and stops this from happening. Or you're traveling to site, and there's an accident which prevents you from reaching your site. Or there's a landslide that prevents you from reaching your site. That's a physical obstruction.
Or the police checkpost and go to the site, which is obstructing due to law.
If there is police that prevent you from entering your site, that could be a physical obstruction. But usually that will go with a physical obstruction. People don't like the project. The local people come and they force you off the site. That's a physical obstruction.
And Mr. Christian, there is another option also. There is or between physical obstructions and physical conditions.
Yeah, if you can come up with a good remember, you can use any claim. You can use any clause to claim. The question is, can you substantiate it? Can you prove it? If it goes in front of a arbitrator or in front of the engineer, can you show him that in a balance of probabilities that physically you were not able to continue with the work? But remember, physically is not legally. Be careful about that. Maybe legally could be your better approach. Just consider that.
So in your opinion, the physical impossibilities are more stringent or less stringent than the legal impossibilities?
Yes, I would, as a general rule, I would think that is the more difficult thing to prove. I may be wrong. Some people may say no, but look at this, this, and this, and it is definitely better. All right, let's continue to the next question.
Thank you. Thank you very much, Mr. President.
Pleasure. Any more questions, comments? Zola, do you want to still continue talking?
Thank you, Mr. Christian. I think I got the answers.
All right, brilliant. Any other questions, Naheem, Akhtar? Do you want to still have something?
Thank you, Mr. Christian. I think that would be all. You have very thoroughly answered each and every question of us. And
All right. Mohammed Ali Sahid, would you like to share something with us? Any more hands that you want to do? We've got the time. I'm happy to continue.
Mr. Christian, I want to ask that Pakistan Engineering Council is using 1987 as a red book. Am I right? Then why they are not have shifted towards FIDIC 2017?
Say again, I didn't hear you well. Please just repeat the question.
I want to ask that which version of the FIDIC we are using. As per my understanding, we are using 1987 FIDIC red book as a current PC building document.
That really depends on the specific contract. FIDIC 1987 is generally used in Pakistan for all national contracts, but it's not necessarily the case. There are other projects which use FIDIC 2017. They are using FIDIC 1999. The one that people that I'm working on right now, we were using FIDIC 2010. So you need to go and have a look at the specific contract that you're using.
But as some rule for the government of Pakistan projects, national projects, which government offers as a client, I think for that 1987 FIDIC is being used.
Yeah, very important when it comes to claims. Don't think. Go and read your contract. Find out which one it is. We often find that in engineering is people said, yeah, but on this project we this, and on that project we that, or that guy said the following. It's important, always go back to your existing contract. Go and check which one it is.
And the PC bidding documents available on the PC website, which version they are using of the FIDIC?
Currently, the ones available on the website is for the red book is the 1987 and the 1987 red book and yellow book are the ones that are on the website.
As I understand, the red book is for civil works and the yellow book is for the E&M works, electrical mechanical works.
Generally, yes, especially in the old one. But if you look at the new FIDIC yellow book, you can actually also use it quite well in areas where the contractor takes the design responsibility.
Both for the electrical, mechanical, and the civil works?
Both, yeah. We had previous contracts where you can use the yellow book. The difference between the red book and the yellow book is the red book, the design responsibility is taken up by the employer, usually the engineer.
In the red book?
The red book. The yellow book is the contractor is taking the responsibility for the design, like with E&M.
And this is applicable, yellow book applicable in case of 2019 and 99 and the 2017 version of the FIDICs.
Yes, this is applicable. The way that the yellow book is written for these contracts, you can use it for for civil works as well. The way how the older ones are written, it is not so good to use the yellow book for civil works. It's possible, but I will not recommend it. All right. Good. Next question.
Thank you.
Not a problem. Mr. Nahim Akhtar, do you still have another question? All right. Fazula, do you have
I think
another
that
question?
would be enough, sir. I think.
Okay. Ajal Haider, do you want to say something further?
No, sir. I'm more than clear, sir. Thank you. Thank you for
Okay,
the time,
great.
and I think we are done with questioning, so we should end this. As we have
Nahim
other classes.
Akhtar?
One last thing.
Mohammed, you can continue.
Somewhere I have seen on the slide FIDIC 2010 PB. What is PB?
Pink Book. It
And what
stands
is
for the
that?
Pink Book. 2010 is the bank harmonized multilateral bank book, which the people like the World Bank and JICA and those are using. And it is similar to the Red Book, and that's why we call it the Pink Book.
Is there any difference with regard to the design onus of responsibility? Onus of design responsibility in the Pink Book?
It's exactly like the Red Book. It is the design responsibility in general lies with the employer. There are certain things which can be given to the contractor, but in general, the main works responsibility of the design responsibility lies with the employer.
And it is only available in case of FIDIC 2010, none other version of the FIDIC.
No. The FIDIC 2010, which is the Pink Book, which is the one that the banks are using, is very similar to the FIDIC 1999 Red Book, just with some additional items which the bank wanted in.
Okay.
All right. Gents, if you finish with your questions, please be so kind as just to lower your hand, then I know which are still new people. Mr. Mohammed Yassin, do you want to proceed?